Court does call the case, People versus Fleming Davis.
I guess Marie Canha, going to be finishing in for Mr. Childers.
And once again,
You said Jeremy Davis, Yana?
Fleming Davis. Come on up, sir. I don't know where your attorney is, but hold on. I'm looking for Miss Cannon,
Okay.
as usual.
Oh, coming right.
So,
How you doing, man? Thank you.
switch that.
Man,
Second.
Have you seen Miss Cannon?
She's there in the office.
not. Give me 1 second. You aren't believing it, but a handcuff to a chair might work.
Your Honor, we'd be requesting an adjournment. I don't know if there's a green form in the.
There is not.
Okay, I apologize.
You don't have the attorney or a green.
I'm standing in for Ms. Cannon, Your Honor. We'll just be requesting an adjournment. We had not been able to make contact with Mr. Davis, so since he's here, I'll get proper contact information.
Any objection from the people?
None, Your Honor.
What?
Oh.
Naza was just gonna hand.
I'm coming for everybody today, Your Honor. I'm so sorry.
Welcome to the office.
I'm sorry.
You have no objections to adjournment. Just kind of a warning to defendant to make sure he stays in the victim, and I'll leave it at that.
Okay, I'll talk
For now.
Thank you.
Probable cause conference, March 20th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you.
Thank you. Court calls the case of the People versus Jeremy Davis.
Ashley Lonnie for the people.
Assistant Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of Mr. Jeremy Davis. Mr. Davis, state your name for the record.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary exam.
All discovery is complete.
Yes, to our knowledge.
People have their witnesses available on the 18th.
Your Honor, could we go one additional week, please?
Any objection to that?
No, that's fine, Your Honor.
Preliminary examination in person will be set March 25th. Is it?
Yes, sir.
March 25th, 2025, 9 a.m. before Judge Moore.
Yes, sir.
Judge Moore.
Thank you, Judge. You got my number?
Bond will continue. Court calls the case of the People versus Dennis Dukes.
Ashley Lonnie for the people.
Assistant Public Defender Asli Bashir here with Dennis Dukes.
Your name? Dennis Dukes. Thank you.
We would like to request the earliest possible exam date. To our knowledge, discovery is complete.
Would the people have their witnesses available the 18th?
Your Honor, the people would request to go 1 week beyond that. The defendant is out of custody and several exams were set on the 18th already this morning.
I know, but I have great faith in the attorneys around here that you can do it.
Thank you, Your Honor. We'll do the 18th.
You will go with the 8th. Thank you.
Thank you, Your Honor.
Preliminary examination in person, March 18th, 2025, 9 a.m. That's before Judge Barr. Bond will continue. Thank you. Court calls the case of the People versus Mohammed Farha.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
good afternoon, Your Honor. Assistant Public Defender Qasim Mr. Mohammed Farha, who is present to my right. Can you state your full name for the record, please, Mr. Farha?
Mohammed Hassan Farha.
Your Honor, today we're going to be asking for an adjournment. My client is scheduled for an intake at the Sacred Heart for rehab on Monday, March 10th. So we would just be asking for about a month adjournment so that we can show some progress. Negotiations are ongoing between me and the prosecutor.
Any objection?
No objection, Your Honor.
Proper cause conference, April 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Jermaine Fletcher.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
In Your Honor, Alexis Plumey, Assistant Public Defender, appearing on behalf of Mr. Fletcher, who is on Zoom. Mr. Fletcher, could you just unmute and state your name?
Got your camera. You need to unmute, Mr. Fletcher.
Mr. Fletcher, there should be
Yes,
like
I'm
a
here. I'm
mic.
here now. Yeah.
Perfect.
Say your
Jermaine
name.
Fletcher.
Thank you.
Your Honor, I am requesting a 2-week adjournment. I do have that sheet here if I could approach
Yes.
and hand it to you.
No, that's okay. No. You relax. Thank you for bringing this to me.
I did say, can I approach?
No, I know. No, you can approach. Not sure you should have to, but that's okay. March 20th, 2025.
Thank you, Your Honor.
Thank you, Your Honor.
No. We were good. We worked it out. Court calls the case. People versus Demond Harris.
Good afternoon, Your Honor. Raymond Cook for the people.
Brian Bowling on behalf of Mr. Harris. Mr. Harris, are you present? Your Honor, I spoke to Mr. Harris yesterday. I expected him to be here today. I'd ask you to consider adjourning this probable cause conference to a subsequent date so that I can get Mr. Harris here.
Bench warrant on 10,000 cash surety. That warrant will issue immediately.
Thanks, Judge.
Thank you. Court calls the case People versus Brian Hart.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
And Laura Yagi, Assistant Public Defender, with on behalf of Mr. Hart, who's approaching council table.
Brian Hart. Thank you.
Your Honor, based on the circumstances, the prosecutor's office is opting to not proceed, and the people are moving to dismiss this matter.
Wow.
You would join in that motion, of course, no objection.
Case is dismissed.
Thank
very
you.
much, Your Honor. Thank you so much.
Or I can just.
I appreciate
Good luck
it.
to you.
Court calls the case People versus Christopher Holt.
Good afternoon, Your Honor. Raymond Cook for the people.
Your Honor, on behalf of Mr. Christopher Holt, who's approaching. Mr. Holt, state your name for the record, please. But do you have a green form, Your Honor?
Did you fill one out?
I do have an extra one just in case.
Did you fill one out?
I had someone do it for me.
Okay, I have it then.
Thank you, Your Honor. We're requesting an adjournment, Your Honor. We're currently in negotiations with the people. We need a restitution amount.
How much time are you looking at trying to get that?
2 weeks is fine, Judge.
March 20th, 2025, 9 a.m. or as your invite indicates, bond continued.
Thank you, Judge.
Okay.
Okay.
Court calls the case People versus Candace Huddleston.
So Bashir on behalf of Candace Huddleston, who appears via Zoom.
Huddleston, can you state your name, please?
Candace Huddleston.
Thank you.
Thank you.
And we request a brief adjournment for further negotiations. There's just some documentation I need to provide to the prosecutor. So 2 weeks should be enough.
Probable cause conference, March 20th, 2025, 9 a.m. Bond continued.
Thank you, Your
Thank
Honor.
you.
I don't have. She didn't give me green. I know, she has it. She left because she thought she might have to approach. You know? Yes. Court calls the case of the people versus Fidel James.
And on behalf of the people,
Your Honor, Alexis Plumai on behalf of Mr. James. Mr. James, could you unmute and state your name?
You're muted, Mr. James.
Yes, Claudel James. Can y'all hear me?
Thank you.
And Your Honor, we are requesting to set this for preliminary examination. Discovery is complete to my knowledge.
People have their witnesses available on the 18th.
we'll do our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. before Judge Moore.
Thank you.
Sound will continue.
Thank you.
Thank you. Court calls the case of the people versus Craig Jones.
Ashley Lonnie for the people.
Your Honor, Alexis Plumai on behalf of Mr. Jones, who is approaching. And Mr. Jones, could you state your name for the record?
Craig Jones. Alice Cowboys.
Your Honor, we are requesting a brief adjournment to the 20th, just so I can continue to try to work out a potential global resolution on Mr. Jones' files.
Without objection, probable cause will be adjourned March 20th, 2025, 9 a.m. Continue. Thank you. Court calls the case people versus Lamar Jones.
And on behalf of the people, Your Honor.
Brian Bowling on behalf of Mr. Jones. Or Jones. Your Honor, plea offer has been made, which I discussed a little bit with Mr. Jones today. He would like some time to consider it. This is in case we would keep it open for us. So just a couple weeks, it should be sufficient.
Probable cause conference, March 20th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
All right, thank you. Court calls case people versus Lamine Kaba. Lamine Kaba.
Ashley Lonnie for the people.
Defender, it's on behalf of Lamine Kaba. Lamine? I was in contact with him just before yesterday. He is supposed to be here. Can we just briefly pass? Maybe I can contact him, see if he's in the hallway outside.
I do that rarely. So that'd be it now. Judge will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you.
Court calls the case people versus Amal Kasham.
Good afternoon, Your Honor. Raymond Cook for the people.
Asli Bashir here on behalf of Amal Kasham, who appears via Zoom.
Hello,
Hello, state your name.
Mr. Amal Kasham.
Thank
Yeah.
And we request a brief adjournment just to provide some documentation as part of negotiations with the prosecutor.
Oh, it's part of it. Gotcha. All right, probable cause conference. Will the 20th be enough time to get that?
Yeah.
March 20th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
All right, thank you, Ms. Kasham.
Thank you. Bye.
Court calls the case people versus Zachary Copella Frendakis.
Frendakis, Your Honor.
All right. Don't laugh at me. There's like a bunch of letters.
No, it's okay. A lot of people butcher it, so I'm okay with it.
Wow.
Assistant,
No, he just called me out. Your client just called, never mind.
and Assistant Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of Mr. Copella. Mr.
You didn't
Copella, could
even
you state
bother
your?
with that last name.
I'm,
After
you
you
know,
go with
I
your last
learned.
name, you didn't even bother with that last name. You didn't say anything about it. You just left off half of it. That's fine. Go ahead.
I just go by Zach Frendakis.
Rendagus.
Frendakis.
Oh, I still did it wrong.
That's what I said.
Yep.
He still talked about it. Go ahead. What are we doing?
Judge, you're requesting an adjournment in this matter. There's just some more media that we need to review with Zach.
Will the 20th work for you?
That should be fine, Judge.
March 20th, 2025, 9 a.m. Or as your invite indicates, bond considered.
Thank you.
Thank you.
Thank you, Your Honor.
You. Court calls the case People versus Eric Coombs.
Good afternoon, Your Honor. Raymond Cook for the people.
Stephanie Kennedy, we have the school board.
Your Honor, I've not had any contact with my client. I did poll the gallery. Nobody responded. I do not believe he is present.
Bench warrant will issue for defendant's failure to appear. Bond 10,000. Cash surety. That warrant will issue.
Thank you, Your Honor.
Court calls the case People versus Natasha Lawson.
Ashley Lawley for the people.
Assistant Public Defender Chinazi Carey, I can really on behalf of Miss Natasha Lawson approaching. Miss Lawson, when you get here, could you state your name for the record, please?
Natasha Lawson.
Natasha. Judge, we're requesting an adjournment in this matter as well. We're still in negotiations with the people.
March 20th, 2025, 9 a.m. Bond continued. Thank you, ma'am.
No. Paperwork. Okay. Thank you, Judge.
Court calls the case People versus Alante Lindsay.
Ashley Lawley for the people.
Lindsay.
Your Honor, Alexis Plumai, Assistant Public Defender on behalf of Mr. Lindsay. And Mr. Lindsay, could you just say your full name when you get up here?
Alante Lindsay.
Thank you.
Your Honor, we are respectfully requesting a preliminary exam. And discovery is complete to my knowledge.
People have their witnesses available the 18th.
We'll try, Your Honor.
Preliminary examination in person, March 18th, 2025, 9 a.m. That is before Judge Barr.
Thank you, Your Honor.
Your bond will continue. Thank you.
Yes.
Court does call the case of the People versus Donald McKenzie.
Good afternoon, Your Honor. Raymond Cook for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. McKenzie, who approaches. Mr. McKenzie, can you please state your name for the record?
Donald McKenzie.
Thank you. Your Honor, we're here at PCC today. It's my understanding that my client will be pleading to an added count of a failure to return rental property under 750-362A4A. It's a 1-year misdemeanor and over $2,000. And my understanding is that the felony will be dismissed.
Do I have a plea form?
That I don't know. Oh,
I can start filling one out.
okay.
I'll pass it.
Thank you.
Court calls the case People versus Taisha Morgan.
Ashley Lawley for the people.
Asi Bashir, on behalf of Taisha Morgan, who appears on Zoom.
Morgan, can you state your name, please?
Taisha Morgan.
Thank you.
I request a brief adjournment to counsel Ms. Morgan on a potential path to a resolution in this case. This should be the final adjournment in this matter, I believe.
Probable cause conference, March 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the cases of the People versus Nicole Nelson.
Good afternoon, Your Honor. Raymond Cook for the people.
Your Honor, Assistant Public Defender Alexis Plumai on behalf of Mr. Nelson. Mr. Nelson, could you say your name?
Nicole Nelson.
Thank you.
Your Honor, I believe the court is in receipt of the plea forms on these two cases. Mr. Nelson will be pleading to an added count 2 of attempt resisting and obstructing on the case ending in 0946. And count 1 will be dismissed. And on the case ending in 1352, he will be pleading to the misdemeanor of controlled substance use. And count 1 will be dismissed.
Right, that being a 1-year misdemeanor.
Yes.
That's the court's full understanding of the agreement. Is that correct from the people?
Yes.
Sir, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Nicole Nelson.
All right, Mr. Nelson, it's this court's understanding that you were going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes.
All right. The first charge is contained in file 0946 or ending in 0946 is the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
The other charge in the other case ending in 1352 is the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation?
No, Your Honor.
Are you on parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of these offenses?
Yes.
Starting the case ending in 0946, on the date of April 28, 2024, at the location of 4970 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, did you come into contact with officers from the Pittsfield Department of Public Safety?
Yes.
What happened that makes you think that you're guilty of this offense?
So what happened is that he put me in the car, and all I really remember at the time was that I wanted to say something.
Okay, you're breaking up badly, sir.
Okay, can you hear me?
Okay, so you came into contact with the officers. Were they trying to arrest you?
Yes.
And during the course of their process in arresting you, what did you do that makes you think that you're guilty of this offense?
I put my foot in the door before the court.
All right, so just so that I'm clear, put your foot in the door so that it wouldn't close, and that's the door to the patrol car?
Yeah.
Okay,
Yeah.
so in that
Yeah.
way you attempted to obstruct their arresting you, is that correct?
He already had me arrested, but yes. Yeah.
Oh, he had you in cuffs, but he was trying to transport you. And you put the foot in the
Right.
door. You put your foot in the door to make it more difficult or to resist or obstruct your arrest. Is that correct?
Correct.
All right. Going to case 1352. On the date of July 8, 2024, at the location of Washtenaw Avenue near Gulfside in Pittsfield Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
To be honest, Your Honor, I do not remember. I do not remember. I cannot recall, or I can't say I did or I did not.
Your Honor, was not aware that Mr. Nelson did not remember that. Perhaps we could pass the matter and I can call him and discuss a no contest plea and print a police report for you. I apologize, Your Honor.
All right, so here's what I'll do. On the other case, have I complied with the court ruling? Would it be proper to accept a suspended split?
Yes, Your Honor.
Yes, Your Honor.
Court on case 0946, court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in that matter will be April 9th, 2025, 9 a.m. That's before me. Bond in that matter will continue. All right, I'll pass the other matter. You can go call him, talk to him, see what he wants to do.
Thank you.
Thank you. Sir, you'll have to remain online, but we'll recall your other case back up after you talk with your attorney. Court calls the case, People versus Matthew Olet.
Andrew Children on behalf of the people.
Assistant Public Defender Qasim Balesi on behalf of Mr. Matthew Olet, who is present to my right. Can you state your full name for the record, please, Mr. Olet?
Matthew Olet.
Your Honor, at this time, we're going to be requesting an adjournment for discovery and to continue negotiations.
Probable cause conference, March 20th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Antoine Patterson.
Good afternoon, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson, who approaches, Your Honor. Mr. Patterson, can you please state your name for the record?
Antoine Patterson, Sr.
Thank you.
Thank you. Your Honor, it's my understanding that the court just signed a protective order on this case yesterday. We're not quite in receipt of the CAC video, although it's my understanding that it was sent yesterday. We were just requesting 2-week adjournment so that we have time to review that.
That's so accurate, Your Honor. The discovery was sent over yesterday. They should receive it shortly, hopefully. No objection to the adjournment for that purpose.
March 20th, 2025, 9 a.m. or as your invite indicates, Bond will continue.
Thank you, Your Honor. Thank you. All right, you're all set. We'll be in touch. Thanks.
Court does call the case People versus Sunita Payne.
Ashley Lonnie for the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Payne, who approaches. Payne, can you please state your name for the record?
Hello, I'm Sunita Payne.
Thank you. Thank you. And Your Honor, after speaking with Ms. Londy in this matter, we are hopeful for a resolution, but at this time, we are asking the court to set this for preliminary examination. All
That's
discovery,
correct,
to my
Your
knowledge,
Honor.
is complete.
And I don't think there's going to be any objection to the 25th or a little bit later. We're just hoping to kind of come together in court and figure out where we're going.
Thank you.
And all discovery is complete.
To the best of our knowledge, Your Honor.
All right, so preliminary examination in person will be set March 25th, 2025. Without objection, 9 a.m. That is before me.
Okay.
Bond will continue.
Thank you.
Thank you. Court calls the case of the People versus Aaron Piccini.
Good afternoon, Victoria Burton Harris, Chief Assistant Prosecutor appearing on behalf of the people.
Assistant Public Defender Chelsea Vergiles with and on behalf of Aaron Piccini. Mr. Piccini, please state your name.
Aaron Piccini.
Your Honor, we're asking for an adjournment in this case. We do have a resolution. However, it requires him to be accepted into 14B Recovery Court. I have a form signed with permission of Ms. Burton Harris. I would ask the court to sign that.
All right. How much how long they're taking to do that, but let's do it this way. I've signed that and signed the referring form. I will set probable cause conference March 27th, 2025, 9 a.m. or as your invite indicates. All right. Bond will continue. Thank you.
Thank you, Your Honor. And can I get a copy of that form? Or, I'm sorry.
Sorry about what?
Will it be sent to the recovery court or can I get a copy so I can send it?
She has some nice things, though, doesn't she? I mean, she's really nice about how she has. Very respectful. I'm like, son. Yes. Can you take care of that, please?
Thank you, Your Honor.
Thank you, Miss. Court calls the case of the people versus Thurman Pool.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Thurman Pool. Mr. Pool, please state your name.
Thurman Pool.
Your Honor, I'm requesting an adjournment in this case as well. We have received discovery now, and I would ask for time to meet with him and let my client review that discovery as well.
Probable cause conference during March 20th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the case people versus Alan Reed.
Brian Bowling on behalf of Mr. Reed.
Alan Reed.
Your Honor, Mr. Reed is prepared to waive his right to the preliminary examination.
Is that correct, Mr. Reed?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Will acknowledge receive the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
28.
April 28, 2025, 1:30, Judge Hamud.
Thank you, Your Honor.
Thank you. Bond will continue. Court calls the case of the people versus Martez Richard.
Is that on behalf of the people, Your Honor?
And Laura Yagi, Assistant Public Defender with and on behalf of Mr. Richard, who's approaching counsel's table. Can you state your name for the court? And sorry.
Martez Richard.
And you're, sorry, Your Honor, there are two matters here. We do have discovery in one, but unfortunately, I believe there's outstanding discovery in the second. So we would be asking for a brief adjournment to obtain that discovery, continued discussions.
And that's correct, Your Honor. I did request that discovery in that case yesterday, and if we could be heard on bond as well.
All right. But you're requesting discovery on both cases or an adjournment on both cases?
I am.
Probable cause conference will be adjourned March 20th, 2025, 9 a.m. As to bond.
Your Honor, we were informed this morning by the victim that the defendant, when he was in custody, check this, he did try to call her number 6 times from jail when he was in custody. And since release, he's been trying to contact her by call, text, and Facebook. She has not answered. And he did file a police report with, was it YPD? With YPD, and so that could be future charges coming because of that.
Response?
Yes, Your Honor. So first of all, this is the first I'm hearing of this. I don't know whether the calls were made before or after the arraignment. Obviously, I think that's really crucial to know if the calls were made before he was told not to have contact with her or not. This is someone he's had a relationship with for 14 years. He has 4 children, this person. They've had kind of an off and on relationship for the past few months, but my understanding is she saw on Facebook that he was dating another woman and got very angry recently. Obviously, I would ask the court to continue his bond, obviously continue the no contact order until, and potentially even set this for bond violation on the 20th, but until we have further information about what that bond violation is, until we have the police report or until we have information that the jail calls were made after his arraignment. My understanding is he was given a PR and released pretty quickly after. So again, I don't know, but it's very possible those calls were made before he was actually told by the court not to have contact with her. And we haven't been presented any evidence whatsoever of the actual communication or attempted communication. So until that time, I would ask that the court continue his bond.
Also, I got my job. I'm supposed to be at work.
Okay. And the other thing is Mr. Richard is a manager still at Burger King, right? And he just got a new apartment. He had been working on getting this apartment through his caseworker for like 8 months, and he just moved into that new apartment. And I know he was extremely concerned about losing that apartment if he loses his job, which would, of course, be at risk if he was to be incarcerated.
And I've been homeless for like 7 months.
Check the dates on the attempted calls from the jail.
All right. Well, here's what I'll do. I'll pass it momentarily, let them check the dates, compare them to the arraignment, make a good point in regard to that. But there are also other calls.
Yes, the victim informed us that he's been trying to text, call, and connect her on Facebook multiple times. So she did file a police report on those.
On those things. Do we have a copy of that report?
Not yet. I believe she filed it yesterday, so we haven't received it yet.
Can somebody try to call over to YPD and see if that report's right? Just make the call. Please. You think I know what the answer is, but whatever. All right, I'm gonna pass it, sir. You're not to leave the courtroom.
Your Honor, I got my job.
Sir?
Because we don't even know what's going on. So just.
All right, I'll recall the case of the people versus Nicole Nelson.
Good afternoon again, Your Honor, Raymond Cook for the people.
Your Honor, Assistant Public Defender Alexis Plumey on behalf of Mr. Nelson. And Mr. Nelson, could you say your name one more time?
Nelson.
And Your Honor, we are going to continue ahead with the same plea agreement as was put on the record previously, but Mr. Nelson will be pleading no contest rather than guilty due to a lack of recollection.
Mr. Nelson, you now
Yes,
wish
Your
to
Honor.
plead no contest to the charge of use of a controlled substance?
Yes, Your Honor.
All right. And sir,
Yes.
you answered all of the questions as it regarded the case. You realize all the rights I explained to you would apply to a no contest plea as well?
Yes, Your Honor.
All right. You understand, and 2 things about a no contest plea, I would be reviewing the police report and taking those facts as true. You understand that?
Yes, Your Honor.
All right. And that it also means that you're not desirous or wanting to contest this amended charge of use of a controlled substance. You understand that?
I'm sorry, can you repeat that again?
It means that you're not wanting to contest or fight the charge of use of a controlled substance. You understand that?
Yes, Your Honor.
All right. And you also understand that the court, for purposes of sentencing, will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Do you have any other questions about a no contest plea?
No, Your Honor.
All right. And so now to that charge of use of a controlled substance, that being use of cocaine, how do you plead?
No contest.
All right. Court has been provided Pittsfield Township Department of Public Safety report for their case number 24-11243. Any objection to the court having reviewed that report?
None from the people, thank you.
No, Your Honor.
All right. Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense counsel. In this case, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation is and report is ordered at 15A1 probation. Sentencing in this matter will be April 9th, 2025, 9 a.m. That is before me. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court recalls the case People versus Donald McKenzie.
Good afternoon again, Your Honor. Raymond Cook.
Assistant Public Defender Jay Bellinger on behalf of Mr. McKenzie, who approaches, Your Honor. Can you please restate the matters?
Donald McKenzie.
All right. Court has now the plea of form agreement that indicates that he will be pleading guilty to the charge of failure to return rental property valued at 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs, and I think 3 times the value of the property. Upon his successful guilty plea to that charge, count one would be dismissed. That's the court's full understanding of the.
That is our understanding as well, Your Honor.
That's correct, Your Honor.
All right. May I have? Sign in. Yes, he did. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Donald McKenzie.
All right. Sir, it is this court's understanding that you're going to plead guilty to a charge of failure to return rental property valued at 200 to 1,000.
Yes, sir.
All right. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes, sir.
Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you're indeed guilty of this offense?
Yes.
On the date of June 26, 2023, at the location of 455 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, what'd you do on that date involving a vehicle from Enterprise Rent-A-Car that makes you think that you're guilty?
Well, I rented the car myself, and I didn't. I wasn't able to return it in time.
Okay. You rented the car. For how long were you supposed to rent the car?
Honestly, Your Honor, it's hard for me to really recall.
May I, Your Honor?
Please.
So you rented a vehicle from Enterprise, and you had a contract on that rental. And at the time of that the contract expired, you failed to return the vehicle.
Yeah.
And the police had to recover that vehicle.
Yeah.
And that vehicle was worth anywhere between $200 and $1,000 for purposes of this plea.
It was worth in excess of $200. The vehicle.
Yes.
Okay. It wasn't a Toyota. All right. No, I'm kidding. Wow. What's that bad? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be April 9th, 2025, 9 a.m. That is before me. Bond will continue. All right. Thank you.
Thank you, Your Honor.
On the left, as you walk down the hallway, my probation department, you can stop in there and start the process.
Yes, sir.
Thank you. Court does call the case of the People versus Sonia Cook Taylor.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Wendy Barnwell, P42-505, on behalf of Miss Sonia Cook Taylor. I think that's what you said, right, Judge?
That is what I said.
Good.
So, what's your name, ma'am?
Sonia Cook Taylor.
Thank you. And what are we doing today?
Your Honor, we're requesting an exam.
All discovery is complete.
Yes, I do have paper and electronic.
People have their witnesses available the 18th.
Yes, Your Honor.
Preliminary examination in person, March 18th, 2025, 9 a.m. That is before Judge Moore.
I'm here that day, Judge, in front of Judge Barron, an exam.
It's only about.
Can we do both
50-foot
at the same
walk.
time?
Oh, yeah. It's just
Okay.
a walk. They'll be right next door.
Okay, good, thanks.
All right, thank you. Fine, continued. Court does call the case of the People versus Cynthia Lake.
Good afternoon, Your Honor. David Cook for the people.
Good afternoon, Your Honor. David Shan, on behalf of Cynthia Lake Pier.
Okay, first, and your name, ma'am?
Cynthia Lake Pier.
All right, there has been an added count two on the amended information.
Yeah, Mr. Cook sent that to me. The defendant will stand mute.
All right.
And waive formal reading of the charges.
Defendant having waived formal reading as to count two, standing mute. Court will enter not guilty plea. All right.
Your Honor, we were waiting for an implied consent hearing with Secretary of State that was set up for March the 3rd. On March the 3rd, the hearing officer had the flu and had to cancel the hearing. It was adjourned. We have a new hearing date of April the 7th. We're hoping we can move this out past April the 7th because of the implied consent hearing goes forward and she does lose her license. We're going to have to apply to felony treatment court in order to give her a chance.
Right.
So there are a few different balls in the air here, but that would give us a chance to find out what's going to happen in that hearing before we proceed with the felony charges and now the new high.
How quick do the results on that come?
Instantaneously. I apply consent hearing, we'll get a decision at the time of the hearing.
All right, so if I set this for April 10th, that'll work for you.
That would work, yes.
Any objection from the people?
None from the people. Thank you.
Probable cause conference, April 10th, 2025, 9 a.m. Bond will continue. All right, thank you.
Thank you, Your Honor.
Court calls the case of the People versus Justin Nickerson.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Good afternoon, Your Honor. Tyler Vila, P number 75702 on behalf of Justin Nickerson.
Your name?
Justin Nickerson.
Thank you. What are we doing?
Requesting exam, Your Honor. I believe all discovery has been exchanged, hoping to get at least 2 weeks out.
Hope what you want, but people have their witnesses available on the 18th.
We should, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you, Your Honor. Have a great day.
You do the same. Court calls case of the people versus Andrea Petkovich.
Good afternoon, Your Honor. Rick, for the people.
Good afternoon, Your Honor. Deborah Schlussel on behalf of the defendant, Ms. Andrea Butkovich. She is on Zoom, Your Honor.
Petkovich,
Yes.
I need a camera on, please.
Oh, I'm so sorry. Hold on. Okay, I'm here.
All right. Thank you. And can you state your name?
Andrea Butkovich.
All right.
Your Honor, today is the date and time set for an adjourned probable cause conference. I'm asking for one more adjournment. I believe we will have this matter resolved to stay in this court. We just need some time to work out the details.
March 20th, 2025, 9 a.m. Sure.
March 20th. That works for me, Your Honor. Thank you.
Okay, great. Bond continue. Thank you.
Thank you.
Court calls case of the people versus Robert Trombley.
Andrew Childress, appearing on behalf of the people.
Yes, Your Honor, please dishonorable court, Brandon Bird, PA 734 on behalf of Robert Trombley. Can you please state your full name for the record? Robert Trombley.
All right. What are we doing today?
Respectfully, Your Honor, I would ask for brief adjournment due to the fact that I was disappointed on the case Friday and was able to get a hold of my client. I also need to ask for a video.
Probable cause conference, March 27th.
Sounds good, Your Honor.
2025, 9 a.m. or as your invite indicates, bond in this matter will continue.
Thank you, Your Honor.
Thank you.
We'll have a great day.
Court calls case, people versus Peter Heenan.
And then on behalf of the people.
Good afternoon. Good afternoon, Jackie Moss for and on behalf of Mr. Heenan. We are both appearing via Zoom from separate locations.
All right. Mr. Heenan, can you state your name?
Peter Heenan.
Oh, there he is. Oh, you're blocked by something on my screen. All right. Okay, what are we doing?
Your Honor, today was the date and time set for a probable cause conference. This matter has been adjourned several times in the past due to Mr. Heenan's being in treatment. Today, Your Honor, I have two proposals. Well, first, I don't recall if the plea agreement was ever placed on the record. I know that Mr. Heenan's plea has not been entered, but I'm not sure if the court was apprised to the agreement. The parties did reach an agreement on November 14th of 2024. In pertinent part, a condition of sentencing was that Mr. Heenan was to complete a sober living treatment immediately following his inpatient treatment. Your Honor, I'm happy to update the court that Mr. Heenan has completed the inpatient treatment. He is currently still in the sober living facility. However, as of March 4th, he has 90 days in. He's expressed to me that the facility is good for him and he would like to remain there until June. That being said, if Your Honor considers the 90 days under his belt as fulfilling that part of the sentence, that part of the agreement, I would propose that we move forward today with entering the plea on the record. Otherwise, I would ask for an adjournment until sometime in June so that Mr. Heenan can complete his stay at the sober living facility.
People have a position on that because I think it's going to be, I don't think it's going to be up to me regarding the 90 days. I think it's going to be up to the people.
Your Honor, I had in my notes from Ms. Poisson that it said that he was going to plead to count 2 stalking and to count 1 be dismissed, and it was contingent upon completion of inpatient treatment and sober living program. And she wrote 90 days, so I believe that would be appropriate to enter the plea then today.
Today. All right. And he's gonna plead to,
I'd have to write up a plea form, Your Honor.
okay, you have to write up a plea form. Okay, all right. So why don't we do this? Let me pass it briefly, let the prosecutor write a plea form and so that counsel knows and everybody knows exactly what's happening, okay?
Sounds good. Could I have a breakout room with Mr. Heenan, Your Honor?
I don't do breakout rooms. With Mr. Heenan, I don't, that's the second person that's asked me. First person I said no. And here comes Moss asking for one.
Yeah, I asked Your Honor specifically because I have not had a chance to consult with Mr. Heenan about the possibility of entering the plea on the record today. So I'd just like to briefly go over that with him.
Mr. Heenan, how are you doing?
Very well, Your Honor. Thank you.
You're looking good.
Thank you very much.
Well, you've been through some stuff, right?
Yes.
All right. We'll give him a breakout room.
Thank you, Your Honor.
Was this recorded? Oh, now everybody knows I will do it under certain circumstances. I'm only doing that. I don't like Moss, but I like Mr. Heenan, so I'm going to do it. Okay. All right. We'll give you a breakout room. Thank you.
Thank you, Judge.
Court calls the case. People versus Jack Moniz.
Good afternoon, Your Honor. Joshua Kaplan on behalf of Mr. Jack Moniz. Jack, will you state your name for the record?
Jack Moniz.
Thank you.
Andrew Childers, agreeing on behalf of people.
All right. What are we doing today?
Your Honor, I've been trying to get a hold of people. I haven't been able to. So this time, I think, unless the court is willing to adjourn this, we just set it for an exam date.
I'm willing to adjourn it, but so that
Your Honor, just as a
Go
court,
ahead.
as the court's aware, Ms. Lonnie was assigned to handle this. She had to log off. I'm covering the case.
Got it.
Today. But obviously, as the court's aware that she's been kind of out sick all week, so there's a reasonable explanation why Mr. Kaplan has had some issues with getting her.
Okay. So let me adjourn this out a couple weeks and let you get in contact with him. All right.
I appreciate that.
With him. Probable cause conference will be adjourned to March 20th, 2025, 9 a.m.
Your Honor,
Or
can
as
we
your
do March?
invite indicates.
Could we do March 27th? I apologize. I'm in trial on the.
This is like two things in a row I don't do. Attorneys pick their date and give a breakout room.
And Your Honor, may I have a breakout room with my client to go over this?
Yeah. Everybody got jokes. All right. Anyway, no, we'll do the March 27th, counsel.
Thank you, Your Honor. I appreciate it. Have
All
a
right.
good one.
Thank you. You take care. Court calls the case. People versus Chloe Whitsett.
People.
Yeah. Okay. It's Attorney Hickman. We'll wait her because otherwise she's gonna start yelling at somebody.
Oh, Lord.
Anyway. Go ahead. Counsel, state your appearance, please.
Kia Hickman for Miss Chloe Whitsett. Miss Whitsett, please state your name for the record.
Chloe Whitsett.
How are you, Miss Whitsett?
I'm here, Your Honor. Thank you. How are you?
I'm doing great. Thank you for asking. All right, what are we doing on this case today?
Yes, Your Honor. As you know, Ms. Whitsett has finally been added to the wait list for the 36th District Court sobriety list. I contacted the director. He hasn't responded back to me yet. I also called again today, and the coordinator who monitors the list, he wasn't available.
Okay. All right. Well, certainly that is a key to trying to resolve this case. So I don't mind adjourning it out if we have to adjourn it out so that we can get clarification on that. Okay.
Yeah, it's just moving up on that wait list at this point. You know, she's good to go. We just have to get her up on that wait list.
On that list.
She's on the list. We just don't know her placement.
Yeah, got it. Okay. So why don't would another 30 days you think do us, and then we can see exactly where we are? Or Okay, all right. Well, everybody's been working hard trying to get this through, and
Yeah,
Miss Woodset's been doing her part.
she has. She's been
I don't know
doing
what that-
well, going through a lot, personally. She lost her mom, and there's things in regards to that. So she's doing really good handling all of that.
All right. I'm very sorry to hear that, Miss Woodset.
Thank you, Your Honor.
All right. Probable cause conference, why don't we do April 10th, 2025 at 9, or as your invite indicates. All
Thank
right.
you, Your Honor.
All right. And trust me, Miss Whitsett, while it looks dark, there'll be some light on that. Don't let that send you in the other direction. Okay?
Yes, sir.
All right. You take care of yourself.
Thank
All
you.
right. All right. Bye-bye. Court calls the case People versus Martez Richard.
And Laura Yagi, Assistant Public Defender, on behalf of Mr. Rick.
Your Honor, I think what's on the record, we did reach out to YPD and were informed that we did in fact make a call for service yesterday. However, the report was not written yesterday because apparently the officer wasn't aware of the bond conditions in place. So we are working to get the report written today and hopefully we'll have it by tomorrow. We did receive text messages from the victim screenshots, and some of those were from as recently as I think March 1st, as from the defendant.
And certainly after the date of arraignment.
Yes.
Jackie, I know it's going to be hard for you to respond because, gee, there's no client. The one that I told not to leave the courtroom.
That's
But
right.
I'll let you go ahead.
I haven't seen what the prosecutor is referring to. Obviously, I would ask if the court would consider setting the bond violation hearing for the 20th. And my client was eager to make some calls. I have no representations as to his whereabouts.
Well, and we were kind of informed that he had left the courtroom. So just so that the record is clear, and I had told him not to, that I had personnel check to see if he was still here or had just gone to the restroom or whatever. And he was not here at all. And had indeed left after being told by the court not to leave. So we will not be adjourning the probable cause because he's not here. He decided to he's here and left. So bench warrant will issue in both of these cases for defendant's failure to appear based upon his leaving as well as the preliminary representation to the people. No bond on both of these matters. Don't know where he thinks this is going to get him. And that warrant will issue immediately. And I think these are YPD cases. They are. So after we get that warrant issued, if you could ask the officers over there to go find him, bring him to me.
Thank you, Your Honor.
Thank you. Or does case be versus Margaret?
Brian Bowling on behalf of Mr. Richardson.
Thank you.
Judge, I'm seeking an adjournment. I will just place on the record that Ms. Londi and I resolved an issue with some video I was trying to obtain related to this matter. Now I would just like to get into some plea negotiations with Ms. Londi.
Probable cause conference, March 20th, 2025. 9 a.m. where's your invite indicates bond will continue.
Thank you, Your Honor.
Thanks, Judge.
Court calls the case of the people versus Brandon Smith.
Andrew Children appearing on behalf.
Assistant Public Defender Chelsea Vergils with on behalf of Brandon Smith. Please state your name.
Brandon David Smith.
Thank you.
Your Honor, we have a resolution in this case. He would take the offer if it is still available. We have given the court a signed advice of rights form.
Nope.
I'm happy to write one up if we want to pass it. I didn't know that that's what we were doing.
Okay.
Okay.
Sorry, yes.
No, it's okay. It's because of a lot of different pieces there moving. Let me pass it and then we'll call you back up, sir, and get taken care. All
Thank
right.
you, Your Honor.
Thank you. Court does call the case of the people versus Julian Tebron or Tabron.
Good afternoon. Good afternoon, Your Honor. Assistant Public Defender Kasim Bobese on behalf of Mr. Julian Tabron, who is appearing by Zoom. Could you go ahead and unmute and state your full name for me, please, sir?
Julian Tabron.
All right. What are we doing?
Your Honor, we're going to be requesting a brief adjournment to continue negotiations.
Probable cause conference without objection, March 20th, 2025, 9 a.m. Where's your invite indicates bond continue.
Thank you, Your Honor.
It's really nice. Court calls case people versus Devon or Davion Thomas. Was I speaking French?
Thomas. I'm
Just
sorry,
speaking-
Your Honor.
No, it's okay. I was speaking French. It's
No, you were, Laura Yagi, Assistant Public Defender. Mr. Thomas should be on Zoom. He texted a screenshot that he was on Zoom, and I believe our Zoom request was granted for him to appear on Zoom.
Hello, guys.
Hello. State your name.
Davion Thomas.
All right.
Okay, thank you, Your Honor. We're going to request a brief adjournment in this matter. My understanding is my colleague did make an AIM referral who's preparing or maybe already finished a mitigation report that we are going to finalize before sending to the APA for review for discussion for resolution.
March 27th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor.
Court calls case people versus Adrian Vasquez.
Stephanie Can on behalf of Mr. Vasquez, who's appearing to my right. Mr. Vasquez.
Wow. Wow. No, I called one of your cases and you actually were here.
Judge,
Shocking. You know?
I had
Miracle.
7 today.
This is
It was,
kind of like a blind squirrel finding a nut. It just happened.
I had 7. It
No,
was
go.
1. It was 1.
It was no.
Can you state your name?
Okay, no,
Adrian
you're right. Thank you, sir.
Proud of myself as well. Your Honor, we are just waiting on a couple of bits of discovery here. One is restitution.
You're waiting on a figure.
Yes, because my client is HIDA eligible, but before he makes that decision, he is trying to see how much that would entail possibly. So if once we get that number, he'll be able to make an informed decision about how he would like to move forward.
Got it. How much time before that number can come forward do we?
Well, I've been in contact with Ms. Lundy about it.
Okay.
This is her case. so
Don't
we-
say anymore.
Okay.
Probable cause conference, March 27th, 2024, 9 a.m. or as your invite indicates. Okay. Bond will continue.
Thank you so much, Your Honor.
Court does call the case of the people versus Madison Welsen.
Assistant Public Defender Chelsea Virgils with and on behalf of Madison Welsen. Mr. Welsen, please state your name.
Madison Welsen. Thank you. I have a plea form. Is that what we're doing?
Yes, Your Honor.
All right. Plea form indicates that defendant is going to plead to 2 charges. First being the stated count 2 of operating while intoxicated. The 93-day offense. And also to an added count 4 of use of a controlled substance, the 1-year offense. Upon a successful plea to that charge, counts 1 and 3 would be dismissed. There's also an agreement that it's okay to seek HIDA on count 4. That's the court's full understanding of the agreement. Is that correct, Al?
Yes, Your Honor.
All right, good. And I have it in place, right? May I have the defendant sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Madison Wells.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Correct.
All right. First of all, that you'll be pleading to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order rehabilitative services or community service as the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Correct.
Also, that you're going to be pleading guilty to an added count 4 of use of a controlled substance, that being fentanyl. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. I do have to advise you, sir, that while you're pleading guilty and I'm taking your plea, that you would be sentenced, that I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Correct.
All right. Now, understanding all of that, you still wish to plead guilty?
Yes.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
All right. Hang on a quick second. Okay. You signed an advice of rights form, is that correct?
Correct.
Any questions regarding any of those rights?
Oh, Your Honor.
Look at paragraph 5. See, those are your rights which are part of a trial. You understand that by pleading guilty, you'll be waiving or giving up those rights contained in that paragraph, as well as all the rights contained on that form.
Okay. Yes, Your Honor.
All right. You understand also you'll be giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Correct.
And also because you believe that you're guilty of these offenses?
Correct.
November 30th, 2023, at the location of Rawsonville near Bemis Road in Augusta Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
What controlled substances did you ingest?
Fentanyl.
All right. Were you stopped by the police or was there an accident?
Police.
Pardon?
I was pulled over.
You were pulled over. Why'd they pull you over, sir?
The car was in my buddy's name that I bought it off of, and he had a warrant.
Okay. After you were pulled over, were you ultimately arrested?
Yes.
And were you taken to the hospital?
Yes.
And was there a blood draw?
Yes.
And did the results of that blood draw show the presence of fentanyl and or the derivative thereof in your blood system?
Correct.
All right. Do you have any reason to dispute those results?
No, Your Honor.
All right. And on that date, you were in possession of fentanyl at some point.
Correct.
And had used it. Is that correct?
Yes.
And knew what you were using was fentanyl?
Mm-hmm.
Yes?
Yes, yes, yes.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Defense is satisfied.
Court will accept the defendant's pleas of guilty to counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14H probation. Sentencing in this matter will be April 1st, 2025, 10 a.m. before Judge Barr. Bond with its conditions will continue.
Your Honor.
Thank you. Court calls case People versus Ryan Wheeler.
Assistant Public Defender Jay Bellinger on behalf of Mr. Wheeler, who approaches in the most awesome jacket I think I've ever seen, other than that worn by the King of Pop himself, Your Honor. Mr. Wheeler, can you please state your name for the record?
Yes, I saw it and I didn't know whether he had a glove or not.
It is awesome. Your Honor, my understanding is that there is no additional discovery forthcoming. That said, we would ask that the court set this for preliminary examination.
Okay, so you don't want me to give you the agenda.
No, correct. Thank you.
People have their witnesses available the 18th.
That's fine.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That is before Judge Moore. That is in person. Bond will continue.
Okay.
All right.
That's before that.
Thank you.
9 a.m. Okay. Okay. All right, thanks. Thank you, Judge.
You're welcome. Court calls the case, People versus Jelani Wright.
Asli Bashir on behalf of Jelani Wright, who is approaching.
Thank you.
And we request a brief adjournment on this matter to see if there's a potential resolution at this stage. 3 weeks if possible.
3 weeks?
We have not been able to, the prosecutors changed kind of on Tuesday for this matter, so I think they haven't really been able to negotiate. So if we need to provide documentation, I would rather just kind of give a little leeway so that we don't have to adjourn again. Just to save the court time, you know.
You guys have never been interested in saving time. So I don't know why today. Never mind. March 27, 2025, 9 a.m. Where's your invite indicates bond will continue.
Thank you.
Now they're interested in whether my time is.
Thank you.
Court calls the case, People versus Demetrius Caldwell.
Yes, I'm here.
Andrew Childs, appearing on behalf of the people.
Hey. This can't work this way. Mr. Caldwell?
Yes, sir.
Your attorney is not here. We just get something at 2:05 today. I understand there isn't all right, that's it. He can't just not appear. His client's here. He says he's in jury selection. I'm presuming he knew that all day. And I'm assuming he didn't reach out to anybody at the prosecutor's office.
I've not received any correspondence from him today.
All right. So, Mr. Caldwell?
Yes, sir.
I need you to hold on the line, okay? Because this is, in my opinion, unacceptable. Tell them to find me another attorney. Miss Heath's removed from the case. Court calls the case, People versus Jeffrey Houselander.
Andrew Childs, appearing on behalf of the people.
Are you Mr. Houselander?
I am.
All right, come on out.
Lawyer's here, he disappeared.
Probably not like that last one, but we'll find out. Hey.
Good afternoon, Your Honor. Nicholas Somberg. I'm F. Jeffrey Houselander.
All right. And can you state your name for the record?
Jeffrey Houselander.
Thank you. He's waiving his right to preliminary examination.
He is, Your Honor.
Is that a correct statement, sir?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yeah.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count one with two following. Counsel, you acknowledge receipt of the information waive its reading?
Yes, Your Honor.
And how does your client plead at this time?
Not guilty.
Defendant having waived formal reading, pleading not guilty, court will enter that not guilty plea to both counts. Pretrial in this matter will be set for
April 24th at 1:30 before Judge Slay.
April 24th, 2025, 1:30 before Judge Slay.
Your Honor, I'm in a jury trial. Could I have 1 week further, the 1st of May?
Okay, so they give me 1 day.
They give you 1 day.
So you can go talk to Judge Slay.
That's what time on the 24th?
Yes, it's the 24th at 1:30. I'm presuming that she would have the following week, but you'll have to contact Central Assignment or her chambers to get that.
Thank you, Your Honor.
Bond will continue. Thank you. Thank you, sir.
She's working on it.
Court calls the case of the, okay, recalls the case of the People versus Peter Heenan.
And back to people, Your Honor.
We have counsel present there. Mr. Boss, are you there?
I'm here, Your Honor. I had to get back on the right screen.
All right. So I have a plea form now in front of me that the defendant will be pleading guilty to the offense of stalking, the 1-year offense, and up to $1,000 fine plus court costs. I think up to 5 years probation is also on that. Upon a successful plea to that charge, guilty plea to that charge, the aggravated stalking would be dismissed. There is a condition of sentencing is finishing the current inpatient treatment as well as the sober living program immediately following release from inpatient treatment and follow all medical recommendations for treatment. That's the court's full understanding of the agreement. Is that correct, counsel?
That's correct, Your Honor.
That is correct, Your Honor.
All right, very good. Mr. Heenan, can you raise your right hand to be sworn?
Yes, Your Honor.
You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name for the record.
Peter Heenan.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of stalking. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost, and up to 5 years probation. You understand that, sir?
Yes, I do.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am not, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Between the dates of It's like May 21st, 2024 and May 24th, 2024. What did you do on that date or between those dates? Actually, I don't know the name. Yes. That involved Aaron Heenan that makes you think that you're guilty of this offense.
I violated a PPO and emailed her. I sent some presents for my boys via an Uber when I wasn't supposed to. And then I went to the house to pick up a package when I thought she wasn't going to be there. But her mother-in-law was there.
Okay, and you weren't supposed to be on those premises.
No, I was not.
Right. Okay. Well, I could take the aggravated. Okay. All right. Very good. Counsel, have I complied with the court rule? Because it's a violation of the PPO, so I could take it to the higher charge in any event.
Yes, Your Honor.
All right. Mr. Moss.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be April 2nd, 2025, 9 a.m. before Judge Perry. Bond will continue in this matter. Mr. Heenan?
Yes, sir.
I guess that's between us. It's been a long journey, sir.
Yes.
I'm glad to see you're doing well.
Thank you.
I won't necessarily get to see you. You've got a lot of people. I'll say this to you. You got to just make sure to keep up the faith. Most importantly in yourself in terms of doing this. There were a few times during this whole ordeal that we almost or feared we had lost you. And to see you now is kind of amazing to me that throughout this process, this was able to happen. But that's a credit to your fortitude, members of your family who came to your aid, your attorneys, even the prosecuting attorney and everybody kind of rallying around and trying to make this a success. So since I have to say goodbye to you now, I just wish you all the best. All right, now and in the future. All right. You take care of yourself and do this old judge a favor, if you would, sometime in the future, maybe after you get off probation. You don't have to put a whole lot in there, but just drop me a note and let me know that you're doing okay. All right.
Thank you so much, Your
That
Honor.
would mean a lot to me. All right. You take care of yourself. All right.
Thank you, Your
Thank
Honor.
you. Mr. Moss, great job. Thank you, sir, so much.
Thank you, Judge. I would just like to apprise the court and let the record reflect that I have emailed Mr. Heenan his advice of rights for his electronic signature and will forward that to the court as soon as I receive it back.
Wonderful. Thank you.
You're welcome.
That's a plea form from Smith that's over there.
All right. Take care.
You too, Judge.
Court recalls the case of the People versus Brandon Smith.
Andrew Childers, on behalf.
Public Defender Chelsea Vergil, with and on behalf of Brandon Smith. Smith, can you say your name?
Brandon David Smith.
I have before me a plea form that indicates that the defendant will be pleading. Well, it doesn't say how he's pleading. I'm assuming it's guilty.
Yes, Your Honor.
Guilty to the charge of use of a controlled substance, that being fentanyl, the 1-year offense. Upon a successful plea to that charge, the possession charge, or felony charge, would be dismissed, and it indicates that it's okay to seek HIDA. That's the
74.
court's full understanding of the agreement. Is that correct, counsel?
It was a 7411. I was doing a lot.
I'm sorry. I said HIDA, didn't I? I meant 7411.
That is correct. Thank you.
That's correct, Mr. Joseph.
Your Honor, yes, that's correct.
Yes.
Is it?
Yes, Your Honor.
Yes.
Yes, Your Honor, I had some confusion about what the controlled substance was, but that is correct.
I have the controlled substance being fentanyl.
Yes.
All right. All right. Very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing so help you God?
I do.
State your name.
Brandon David Smith.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance, that being fentanyl. Is that correct?
Yes, Your Honor.
That's a misdemeanor, punishable by up to 1 year incarceration, a $1,000 fine plus court cost. Do you understand that?
I do, Your Honor.
In understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any questions regarding any of those rights?
I have none, Your Honor.
Look at paragraph 5 on that form. You'll see a copy there. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do understand.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am.
Out of what court? Don't know.
15th.
15th District Court. Were you on probation at the time of this offense?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And because you believe that you are indeed guilty of this offense?
That's correct.
On the date of July 17, 2024, at the location of Ellsworth Road near Palisade Boulevard, Pittsfield Township, Washtenaw County, State of Michigan, did you have fentanyl in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be April 9th, 2025, 9 a.m. That is before me. Bond in this case will continue.
Thank you, Your Honor.
Thank you, Your Honor.
There he is. Court does call the case of People State of Michigan versus Zai Shanghai. Now,
Good afternoon, Your Honor. Chief Assistant Prosecutor Victoria Burton Harris appearing on behalf of the people.
And good afternoon, Your Honor. For the record, Orlando Simone, Student Legal Services, on behalf of Mr. Gao.
all right. The record should reflect that there was a brief in-chambers conference. The court is itself, without objection, going to adjourn the probable cause hearing in this matter. I will adjourn it to April 3rd, 2025, 9 a.m., or as your invite indicates. Bond on this matter will continue.
Thank you very much, Your Honor.
Thank you.
Thank you, Ms. Burton Harris. Have a good afternoon.
All right.
Thank you. You do the same.
Court does call the case. I don't want to call that. Miss Rushing's not in. Okay. Court calls the case People versus Emma Mathis.
Thank you, Judge.
Andrew Childers appearing on behalf of the people.
Lawrence H. Margolis with and on behalf of Miss Mathis, who is appearing to my right. Emma, please state your name for the court.
Emma Mathis.
Have before me a plea form. Is that what we're doing?
Yes, sir.
All right. Is the plea going to be one of guilty or no contest? Guilty.
Correct.
Plea form indicates that the defendant will be pleading to 3 charges. Counts 3 and 4 are attempted resisting and obstructing a police officer, the 1-year offense. And count 6 being the operating while intoxicated, the 93-day offense. Upon her successful plea to those 3 charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
It is. Yes.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. I hope you got it. State your name.
Emma Mathis.
Ms. Mathis, this court's understanding that you're going to be pleading guilty to 3 misdemeanor offenses. Is that correct?
Yes, sir.
All right. First is the added count 4 or count 3. That is the charge of resisting and obstructing, attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mhm.
Is that a yes?
Yes.
All right. And then also count 4, which is the same charge of attempted resisting and obstructing, that also being a 1-year offense, $1,000 fine plus court costs. You understand that?
Yes.
And also the charge of operating while intoxicated, the added count 5, That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Court could order community service or any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. Understanding, you also have to advise you, I guess, that while I'm taking your plea, I would not be your sentencing judge. And you would in fact be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes,
All right. Now, understanding all of that, do you still wish to plead guilty
I do.
to the charge of attempted resisting and obstructing as contained in count 3? How do you plead?
Guilty?
To that same charge as contained in count 4, how do you plead?
Guilty?
To the charge of operating while intoxicated, how do you plead?
Guilty?
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form today?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading, you're giving up those rights as well as all the rights on that form.
Yes.
Okay, you have your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of these offenses?
Yes.
On the date of November 25th, 2024, at the location of Platt and Packard Road, City of Ann Arbor, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes.
What'd you have and how much?
At least 3 beers and several shots of tequila.
Were you stopped by the police or was there an accident?
There's an accident.
There was? What happened?
A fender bender. I rear-ended somebody.
Okay. Did the police arrive?
Yes.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital and then to the police station? Or were you taken right to the police station?
I was taken right to the police station.
Were you given a breath test of some kind?
I was offered one.
Pardon?
I was offered one, but I did refuse it. And opted for the blood test instead.
They obtained a warrant and got the blood test, Judge.
Okay, so ultimately you were taken someplace or there was a blood test given at that point?
Yes.
So you did have a blood test. What were the results of the blood test?
I don't remember off the top of my head.
I believe it was 0.29.
Do you have any reason to dispute those blood test results?
No.
All right. And during the course of these series of events, did you come into contact with officers from the Ann Arbor Police Department?
Yes.
And what happened in terms of your interaction with them that makes you think that you're guilty of the offense of attempted resisting and obstructing?
I know that I flailed my limbs and kicked my legs some, and I believe that I struck an officer.
Okay. So they were trying to arrest you at that point?
I believe I was cuffed.
Pardon?
I believe I had already been handcuffed at the
You had already been handcuffed and then you started flailing and potentially striking out at the officers?
Yes.
And you knew that they were in the lawful performance of their duties?
Yes.
And there were 2 officers at least?
Yes.
All right. And in doing so, you would admit that that was resisting or obstructing their attempts to lawfully arrest you?
Yes.
All right, counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
You have, and it would be.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be March 28, 2025, 8:30. That is before Judge Perry. Bond with its conditions will continue. Thank you.
Thank you, Judge.
Court does call the case, People versus Caleb Smith.
Lawrence H. Margolis with and on behalf of Mr. Smith, who is approaching. Caleb, please state your name for the court.
Caleb Smith.
Thank you.
Judge, we are waiting on a couple additional discovery supplements, I believe, from the prosecutor's office. I know there's body cam as well as a download of the phone that hasn't been completed yet. I spoke to Mr. Childers, and for him to be available the next time, we'd like him to be here since he's has a understanding of this matter, and I've been working with him. Would be that, what was that, Andrew, 27?
27.
We'd like to.
Oh, we don't pick.
Sorry?
We don't pick dates.
Yeah, we're seeking to adjourn it for a couple weeks.
Yeah, just part of the discovery request, there was, this is a U of M Police Department case, but Ann Arbor Police ultimately apprehended the defendant. I was able to get that video at the end of the day yesterday, so Mr. Margolis should have that momentarily. And my understanding is Detective Matthews with U of M Police was at our office earlier, coming off some discovery, so.
So this one I was, oh, my teacher told me to put there. So, verification.
Probable cause conference will be adjourned March 27th, 2025. 9 a.m. as your invite indicates. As to bond, how's it going?
How's it going?
It's going good. Attended school and church. I've been going daily, regularly, and my grades are as if I have them right here. I'm ready to show.
May I approach?
Those are the grade classes, like similar here.
And the ones that are not the marks that we would want and expect, we've been advised that those were the weeks that he wasn't here, and those grades are going to be changed imminently.
His participation grade.
Yeah, you have to be in class for cooking.
What'd you send me the other day? A pizza?
Breakfast now.
Nice.
You can do better than that.
Yes,
Yeah.
sir.
Yes.
How's it going with him?
Better. Seeing a therapist, and I even haven't enrolled the one tuition
Pardon?
in the mentoring program Saturday.
Oh,
Signed them up for it, but we can't discuss that yet. A little bit better.
I did forget to let the court know the Miss Barrow has requested, there's a mentoring program, and I can get the prosecutor in your office some information on this. She just let me know about it. It's in, where is it? It's in Ypsilanti. She's wanting to, what's it called?
With
My Brother's Keeper. He was hoping to be able to attend that.
All right. Well, get that information to the prosecutor. I'm aware of their services and programs, so it might be good for him.
I'll get that to them immediately.
Probably outside of myself, they'll be able to tell you that you're not all that. Sometimes you're special, but you're not that special.
Understood.
All right. But everything else is going good with you?
Yeah.
Caleb, why do you think I threw you in jail?
Yeah, to learn a lesson and
to do what?
So like what I believe me is to learn a lesson and that to let know.
Okay, I'll accept that. What lesson do you think I wanted you to learn?
Like, excuse me, if I take a moment to just process any to sorry, I'm just to like help me realize this is what I believe. To help me realize that like me, this is what I realize is that I'm not meant for this, or that to own up, like I don't know, just to say, like I'm just gonna speak from my heart, and that sorry, I'm having trouble talking, but like the lesson I've learned was that I learned that I didn't want to be there, that I would focus on school, and the lesson, even with the get a 3.5 and higher, I've been like aiming for that, and that helped me realize that I can like achieve it. And what else? That's all I have for now. I'm sorry if I didn't say anything clearly. I'm just, but I've learned a lot, and that my actions affect not only just me but others, and that what else?
Just want to keep improving.
Yeah, mostly just keep improving, and that's what I have been doing.
You nervous?
A little bit, yeah.
Why are you nervous?
I'm just not like used to this. Sorry.
Used to what?
Just being here, speaking out loud in front of.
You're not used to being in court, facing criminal charges, that kind of thing?
Yeah, I'm not used to.
Well, then you ought to conduct your life where that won't happen. Right? Part of the reason and what I asked you is why you thought I locked you out, what you were learning.
Mhm.
You know, when you got here, just so that you know this, I watched your mother. And probably the only reason that you're out is because of your mother. A lot of times what people don't realize is that sometimes there is nobody else in the world that cares about you, trying to look out for you, praying for you, except your mother. And I watched that woman sit there as her son was going off to jail. And when he came back out, and in all of that, it was breaking her heart. But I can tell you, and I don't know your mom, but I can tell from the look, I can tell by her posture, she just kept praying. And throughout all of that, and even after all of this, and you, I'm not talking about the criminal charge, but you doing the stuff of violating your bond, that woman never gave up faith in you. That's who you owe it to. Remember something I told you about where you were going to run into problems with me?
Yes, Your Honor.
What was one of the ways you were going to run into problems?
One of the ways was, well, that I believe that when you said if I can't respect my mother or if I can't respect the courts, there was like a problem.
I always believe in letting people know where they stand with me. And I'm not shy. You disappoint her, I'm sending you. We're clear on that, right?
Yes, Your Honor.
Get those grades up. Bond will continue.
Thank you, Judge. See you.
Court calls the case. People versus Xingyi Yu Q.
Alexander, on behalf of the people, Your Honor.
Your Honor, good afternoon. Joe Simon on behalf of Ms. Hu. Ms. Hu, unmute your microphone and state your name, please.
What are we doing on this?
Your Honor, requesting the matter be set for an in-person preliminary examination. My client is presently in the state of California, but she will return.
Okay. When is she returning?
She's going to need a little bit of time to make her travel arrangements, but I talked to her about it. She's, if the court can do the 25th or the 1st of April, either one of those, she'll be able to make either one.
Preliminary examination in person will be set March 25th, 2025, 9 a.m. before me.
Thank you.
Bond people will have their witnesses available.
We'll do our best, Your Honor.
All right. Bond will continue. All right. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Charles Tingley.
Good afternoon, Your Honor. Jacob, on behalf of the people.
Your Honor, Joe Simon on behalf of Mr. Tingley. Mr. Tingley, will you please turn your video on, unmute your microphone, and state your name? Mr. Tingley? Your Honor, my client is in Pelkey, Michigan, which is way.
Is where?
Pelkey, Michigan, which is way in northern part of the UP. And there he is. He has signal issues. Mr. Tingley, state your name, please.
Charles Tingley.
All right. What are we doing?
Your Honor, the parties have a pretty unusual request. We adjourn to today's date for a further investigation with Detective Babbage. But as the court probably knows, Detective Babbage retired. Detective Babbage is resuming a contract at the beginning of May. Because this further investigation could lead to a disposition of the case, the parties are jointly asking if the court would consider adjourning the PCC to a date in mid to late May.
Mid to late May?
Yeah, well, Detective Babbage comes back at the beginning of May. We'll take the first available, but
Simon.
I know. I knew you were going to say.
What do you mean you knew? I am not that predictable.
I do have the green sheet filled out, Your Honor.
Mr. Kennedy is saving you. You know that.
I was hoping that would be the case.
I even put that the people are requesting the adjourn.
Yes, I see that. That is it were for Simon, no, but if for Kennedy, I'll do it.
Thank you, Your Honor.
You're welcome.
You are doing a great job today.
Thank you, Mr. Kennedy.
Probable cause conference, May 22nd, 2025, 9 a.m. Bond will continue.
Did you say May 22nd?
Yes,
That's
May.
my birthday.
Is it?
Yes, it is.
Well, happy birthday.
A better way to spend it.
Yeah. He had to be here. All right. Thank you, Mr. Simon.
Thank you.
Get another one? No, that's this one. And I still don't have Miss Rushing. What'd you say?
What was your question?
Well, I was gonna ask Ann. I think she was looking out for Miss Rushing.
I can see if.
Well, no, she was gonna appear on Zoom
Oh, okay.
because she's taking over Mr. Caldwell's case. Okay, Mr. Caldwell?
Yeah.
Okay, court calls the case of the people versus Caldwell.
Andrew Childers appearing on behalf of the people.
All right, and your guardian is there, correct? She is. Okay, so here's what I'm gonna do. I've signed an order, your previous attorney, because I think this is the second or third time, and I'm just not gonna put up with that. You need somebody that you can count on to be here. So I'm signing an order relieving him or discharging him from your case at this point. And the court, well, the assigned counsel office has, it'd be Miss Sydney Rushing. She was gonna try to sign in to this proceeding, but probably was unable to do that. But she's pretty much here every week. So what I'm gonna do is I'm going to adjourn your case out 2 weeks. Okay?
All right.
All right, so I'm gonna adjourn your probable cause conference. I think that, no, it's actually a comp. So I'm gonna adjourn your comp hearing out to, I don't think we have a report yet, but I'm gonna adjourn it out to the 20th. And 2024 at, I said it at 9, but it may be at a different time. And Miss Rushing will reach out to you. If your guardian, if you could, so we can try to facilitate some things. If you could put a contact information for you into the chat so that we can pull it off, and we'll make sure Miss Rushing has that. Okay. All right.
Yes.
And I'll have your bond continue. Okay. Mr. Caldwell, and your guardian, thank you very much for your patience on this, but I think this will work better for you. All right.
All right.
You.
All right. All right. You guys take care.
All right, you too.
Court calls the case of the People versus Ricky Lee Park.
Andrew Childers appearing on behalf.
Good afternoon, Your Honor. Jennifer Winstead. I'm appearing on behalf of Ricky Parvin, who is present and standing to my right.
This is time set for PCC. You filed a motion to dismiss.
Yes, Your Honor, I did have an opportunity to speak with Mr. Childers, and he is working to get us the remaining discovery. It's kind of a unique case because it does extend through several counties, so we've had some difficulty getting all of the discovery. So we would just ask to adjourn today's hearing out a few weeks to allow us to get the remaining items.
All right.
I don't have an objection. Ms. Winstead and I went through some of the things she believes she's missing. And as she stated, Livingston County Sheriff was involved as well as the state police. So there's kind of an annoying game of telephone and trying to track all these things down. But we did get the Livingston County reports yesterday. So that should help because I at least now have an incident number, which I can cite when I contact Livingston County about any video they may have, body worn camera, in-car, so on and so forth. So I think that we should be able to get definitive answers on whether things do or do not exist now, having that information.
Got it. So I'll adjourn the probable cause conference as well as the motion in this matter to March 27th, 2025, 3 p.m.
Thank you, Your Honor.
All right, bond will continue. Thank you.
Thank you.
Take
Have a
care.
good day.
You too.